I had the privilege to come here oftentimes. In previous keynote speakers, I was exactly where you are now. I was in the audience. So I can tell you that the bar is set really, really high, and I will do my best to be up to the task, this time as a keynote speaker, to try to animate you at least as much as previous keynote speakers were animating me when I was in your position. I have to say that each time I come here, I'm literally humbled to see the efficiency and the dedication of Professor Friedman and her team and the energy they put in this summer school as well as in the center itself. So this is one other reason that I'm really happy to be here tonight with you. The topic I've chosen to discuss is the one which probably pertains to us all. I was thinking that tonight we might talk a bit about history, about courts, but primarily about our expectations from those courts. How do they fit in an overall agenda of transitional justice? How come that we are time and again expecting and time and again being disappointed by the delivery of those courts, and how to make sense of that output and primarily of our role in this process. So on the one hand, tonight we will, for about an hour I will speak, we will try to critically examine the role courts play in the overall transitional justice framework. How are we going to do that? I was thinking to begin by zooming out and trying to talk a bit about our expectations from the courts in general. I wanted to critically examine some of the key narratives or trajectories or even teleologies of transitional justice that we are all aware of. In a minute, we will hear much more about it. And then I will zoom in and showcase all of these problems the way I see them deriving from the International Criminal Tribunal for the former Yugoslavia. Now, why the ICTY or the Hague Tribunal? Well, I have several reasons. My first reason is that this is the court I know best, and it's my firm belief that one should talk about the stuff one knows something. The second reason is that you came to Belgrade, and this court is dealing with the crimes committed in the former Yugoslavia. Actually, this is probably the time to include the audience in a sense. How many of you are in Belgrade for the first time? Welcome. Welcome. The thing is, it's my deep belief that transitional justice is an activity which is also open to the public, engaged with the public. And I'm sure that during your otherwise pleasurable stay, you will get a chance to talk to people around you, and probably you might ask them, what do they feel about the tribunal, or the Hague, as we tend to call it. And some of the responses will probably be quite telling, and I will try to prepare you for some of those responses. So this is why ICTY will feature more prominently in this presentation than some other tribunals. On the other hand, I really hope for your feedback. I'm quite sure that under this roof there are people who are much more knowledgeable about other tribunals all around the world, so I'm eager to see which of these experiences can be compared. Because it is my other belief that any study of conflict is fruitful so long as it is comparative. However, of course, this is much more easily said than done. So, let's start with this zooming out and with examining of this key narrative of international criminal justice. I have to include the audience once more, this time to ask how many of you are pursuing a legal degree or having one? I figured so. And when you come to think about it, this is really unusual, because transitional justice is supposed to be a field which is closely aligned with the law of different kind. And yet, time and again, in different conferences or in different schools and so on and so forth, I see that jurists are not really prominent in the audience. It's prone to be inhabited by sociologists or historians and so on and so forth, human rightists of different kind. And in a sense, it's a pity, because lawyers are able to give us important reality checks on how tribunals really work. And we don't get this reality check. In the absence of it, we, non-legals, are prone to build a rather artificial, mesmerizing view on how the justice is delivered. We get fascinated by the surrounding of the court, by the entrance, by this little thing that the judges have and the wigs and whatnot. And we tend to forget that those are people of flesh and blood, and they make mistakes just like all of us. So basically, there is this potential fallacy of simply fetishizing the courts as such. And it needs to be addressed properly, I guess, in this surrounding. And in a sense, I think that it was non-legals who are most responsible for creating this master narrative, which I call, and not only me, from Nuremberg to The Hague. This is a story, so let me talk you to the story. The story says the following. Second World War came to an end. Victorious allies, primarily four main powers, decided not to simply shoot their enemies, but to put them on a trial in order for the whole world to see magnanimity of their crimes. And hence, International Military Tribunal came about, as well as its younger brother, International Military Tribunal for Far East in Tokyo. Those powers decided, in the words of Robert Jackson, chief American prosecutor in the Nuremberg decided to stay hand out of vengeance and to deal with the things legally. Sadly, soon after Nuremberg, Cold War came about, and in this environment it was impossible to stabilize this court, so there was never a permanent International Criminal Tribunal after Nuremberg. There was this huge gap, so the story says. And this gap closed only after 1989, because when the walls came tumbling down and Soviet Union ceased to exist, conditions were set for new legal order, and within this new legal order, conditions were set for creation of permanent International Criminal Tribunal. So negotiations started, the story says, during 1990s to set ICC and put it into effect. In the meanwhile, history didn't stop. There were conflicts all around the place. Former Yugoslavia, Rwanda, Caucasus region, and so on and so forth. And it was dealt with, the story says, with formation of ad hoc tribunals, mostly by Security Council. International Criminal Tribunal for Yugoslavia, International Criminal Tribunal for Rwanda, for Sierra Leone, for Lebanon, for Cambodia, several other places. Those were, so to say, fillers until a moment that ICC will finally come about. And then in 1999, the story says again, finally the states came together and they signed the Roma Statute, which came into effect soon afterwards. And ICC came in all its glory to, in a sense, augment the new world where international justice will play a much more prominent role than it did beforehand. It happened in an atmosphere of utmost exaltation, and I will just show a small clip to demonstrate the ending of this, this triumphalist narrative.
People from all over the world gathered in Rome to attempt something that had never been done: create the basis for a permanent international criminal court.
In 1998, during the Rome Diplomatic Conference on the International Criminal Court, 160 countries negotiated a treaty to design the world's first permanent international criminal court.
Well, now because it's now closed.
On the 17th of July 1990.
Honestly, it doesn't feel good at all to deconstruct this narrative. I'm looking at these people who are so happy, and these people are mostly members of a huge coalition which was made to bring this court about. This happened in 1999. We are, of course, much wiser 20 years after the fact, and we clearly understand that exactly during the time those people were crying of happiness in Rome, Bin Laden was sitting somewhere in some cave, and history took a completely different turn in the 21st century, sort of rendering much of those hopes from the 90s, pretty much derailing them, right? What we know now for sure is that this trajectory from Nuremberg to The Hague is at best extremely problematic. Even Nuremberg wasn't what we tend to think it was, problematic from a million points of view. Most importantly, and probably most frightfully, ICC, as we all know, so long as we are following what's happening there, is also in deep, deep crisis. So the beginning and the end of that story are tremendously endangered. In a sense, you can claim that this from Nuremberg to The Hague international criminal justice teleology simply does not exist in reality. However, of course, many people want it to exist simply because they have vested a lot of their lives and their hopes exactly in that sort of trajectory. I'm not saying that there are no meaningful continuities. So meet Benjamin Ferenc, or Ben Ferenc. He was a young prosecutor in the Nuremberg Military Tribunal. That was an American tribunal which was organized on the ashes of the big Nuremberg. He was a prosecutor who was instrumental to a couple of really important cases. And after this other tribunal, NMT, he devoted much of his life to the cause of promoting international legal order. And he was extremely happy to find, he's still among us, luckily, and he was really happy to find that by the end of his life all these expectations are coming about. And here you can see this young prosecutor from Nuremberg being wined and dined by International Criminal Court a couple of years ago and sort of being a living testament to a certain amount of continuity. It's a touchy anecdote, but again, I have the feeling that reality in a sense is much more brutal when it comes to discontinuity. If you take a look at the ICC now, and I'm far from expert in ICC, but it needs to be mentioned, you can see that not even the shrewdest way to organize information about what happens there can leave us satisfied. Here you can see many information. You're bombarded by information in this slide. 124 states are party to the Rome Statute, 18 judges, 23 cases. But the crucial points are the following. How many convictions? This is, by the way, a bit of an outdated slide, because in the meanwhile, as far as I understood, Bemba was acquitted on the second level. So basically, you don't really have all that many people who are incarcerated by the ICC or who are being convicted by the ICC. Only a handful. A couple of others are now in the making, let's say, but still, this is not what one can imagine, especially given the yearly budget of this institution, $153 million in 2000, or euros in 2016. So even the greatest friends of the ICC are trying to say that something really worrisome is happening, and we can of course talk how and why a bit later. So since this narrative is coming to a huge pressure, so there is no Nuremberg and there is no The Hague, then the defenders of the narrative would say, okay, look, let's give ICC a chance. It's a really young tribunal, it's a baby, frequently it's said, and it needs time to grow and so on and so forth. And we have, the story says, certain aspects of activity of ad hoc tribunals which show us that this thing can really take off. They mention ICTR, or International Criminal Tribunal for Rwanda, and you can see the statistics here. Here the numbers look much better. It's not 4 persons, but 93 persons had been indicted by the ICTR, 62 sentenced, and so on and so forth. ICTR is not without its own problems, probably the chief one being that all the indicted persons are coming from one side. They are all coming from the Hutu side. And if you would say this to the defender of the narrative, then the defender of the Nuremberg to The Hague narrative would say, hey, look, okay, stop. I have a thing for you. I have the ICTY. And ICTY, in a sense, serves as a safety belt. Since Nuremberg was fishy, since ICC seems to be crumbling, since ICTR stands for victor's justice, but look, we have the ICTY, this is a living testament that the tribunal can work, and then you will most probably be served with these statistics. And these statistics will tell you that the ICTY, which was in function for about a quarter of a century, and is just slowly dwindling as we speak, indicted 161 individuals, and then you will see that majority was sentenced, around 90. The other ones are still in some other capacities or had died during the proceedings and so on and so forth. You will also see that this tribunal was very effective in bringing indicted people to The Hague, where it's situated, which is also one of the problems that ICC has. So you can indict, let's say the ruler of Sudan, but you can't really arrest the ruler of Sudan, right? So they were successful in bringing all these people to The Hague. They were also successful to leave an enormous paper trail behind them, stemming from the fact that over 4,000 people really testified in that tribunal, 10,000 trial days, as I said, quarter of a century, 2.5 million pages of transcripts, and so on and so forth. Indeed, it's an impressive statistics. It's even more impressive if you go in the ICTY, and I still fondly remember this courtroom. I was in it a couple of times. It's indeed impressive, lots of togas and lots of things happening there. Basically, whatever is happening in the ICTY was mostly transmitted in real time, so you could follow it from your own house. This was also quite impressive. So actually, I would want to give a sort of a disclaimer at this point. Indeed, for years, I was monitoring what's happening in the ICTY. I was working alongside people from the ICTY. I was studying what they do. I was really hoping, in a sense, I was a part of this narrative in many ways, thinking that the Balkans would look very differently if it wasn't for that tribunal. And it took me quite a while to understand that things are absolutely not black and white. I kept changing opinions. I was talking to my friends and colleagues. I was telling them, ask me anything, just don't ask me what do I really think about the ICTY, because in the morning I tend to think it's great stuff, you know, without it we would all be in horror, Milosevic would rule, or his wife, or somebody like that. In the evening I would think, oh wow, so many problems there, and so on and so forth. So my own evaluation of the activity of this tribunal was extremely unstable. And then I realized that what I need, and probably what other people need as well, is certain stable yardstick to evaluate things. I'm some sort of a scholar. I'm supposed to figure out the way to measure these things. And I was thinking about what's the real measurement of a success or a failure of a trial. It's difficult to say. How do you say if something is a successful marriage or not? If something is a successful trial? These things are not really prone to objective quantifications. But after a while, I realized that there could be an interesting yardstick. I went to the ICTY's website, and what I did was I took their own accomplishments. There is a part in the ICTY's website which says, okay, these are our accomplishments. They have 5 accomplishments, and please commit them to your memory because we are going to talk about them a great deal tonight. So the ICTY says the following. We did 5 things: holding leaders accountable, bringing justice to victims and giving them a voice, establishing the facts, developing international law, and strengthening the rule of law. These are the latest accomplishments. When I was 10 years younger, accomplishments were something else. I remember that this website was saying reconciliation, for instance. After a couple of years, the tribunal probably came to an understanding that it doesn't make much sense to claim that they contributed to reconciliation. I could say a bit sardonically that they could. There is a standing joke in the Balkans that people in the successor Yugoslav countries can't agree about almost anything, especially anything from the past. But these days, they tend to agree that ICTY didn't do a good job. So basically, this is the only thing that these post-conflict countries can settle on. However, I don't think that this is a sort of reconciliation that the ICTY had in mind. So given that, I was thinking to bundle a couple of those accomplishments, and for the sake of brevity and time, I will deal with them sort of jointly. So let's address holding leaders accountable and bringing justice to victims and giving them a voice. Meet Vojislav Šešelj. Who is Vojislav Šešelj? This photo is taken from 1991, when he was the head of the Serbian Radical Party, ultra-nationalist political organization, and he was also an MP in the Serbian parliament. He was instrumental for the Serbian wartime effort and was visiting front lines frequently, rabble-rousing stuff, bringing people from his party into military units, raising morale and stuff like that, and this is his photo from the field. Vojislav Šešelj surrendered to the ICTY in 2003 under extremely dubious circumstances. We can also discuss them afterwards or not. And he was on trial for over a decade. For about 12 years, he was sitting in the Hague Tribunal. He was accused of many things, but basically the crux of the matter was incitement due to his speeches and crimes against humanity committed by his troops. The trial dragged on, and basically Šešelj succeeded to steal the show. He made the trial a tool and vehicle for his political promotion. So successfully he stole the show. Here you see that he succeeded even in literally dislodging one of the judges in his own case. The Hague essentially didn't know what to do with him in the end, and he was released on humanitarian grounds in 2014-ish or something like that. What did Šešelj do? He returned to Serbia. What does Šešelj do now for a living? He is the president of Serbian Radical Party, ultra-nationalistic political organization, and he is an MP in the Serbian parliament. So he's literally the thing he was in 1991. His views on politics didn't change at all. Here you see him holding a rally after his comeback to Belgrade. And just the other day, from the parliamentary rostra, he was mentioning that the state should do something to criminalize all those Hague lovers who are, undermining Serbian national interests and so on and so forth. Oh, by the way, in case you can't hear me, just let me know so I can start yelling. Why does this matter? Well, if we switch from leaders, which didn't really change their position, to the victims. A month ago, I was traveling with my family through a small township called Hrtkovci in southern Vojvodina. Hrtkovci was a place which was central for the Šešelj's case. In Hrtkovci, there was a sizable Croatian community, and this Croatian community was intimidated by Šešelj, who came there a couple of times in 1992, held a couple of speeches, and organizers from his party were essentially kicking people out of Hrtkovci. Okay. We passed by the car, and we saw the following scene. The blue house in Hrtkovci, which you see on this road, belongs to Vojislav Šešelj. He bought a house in that very place. He painted the house blue because this is the official color of the Serbian Radical Party. If you wonder what the tent also has a purpose. It's also on his property. And this is where a month ago he had held a rally of his party and got himself re-elected for the place of president of the Radical Party. Now, if this is not poking victims in the eye, I don't know what it is. Because in the meanwhile, in absentia, Šešelj was convicted by the ICTY partially and basically solely for this crime. However, he has spent so much time in custody in the ICTY that he doesn't have any time to serve. So he doesn't have time to serve, but he has the time to assemble Radical Party exactly in Hrtkovci for the purpose saying, okay, I will poke you in the eye. You might tell me that this is a lonely example, but there are many more. Meet General Lazarevic and his commander-in-chief during war 1999, General Pavković. Both of them convicted of war crimes in the ICTY. Lazarevic served his time, Pavković is still in jail. You might ask, what is Lazarevic doing after his release? Well, Lazarevic is occasionally lecturing at the military academy. This was a huge brouhaha in Serbia a year ago. And he's also taking part in some public activities. Here you can see him, it's the guy with the glasses right here. in the march of the so-called immortal regiment. It's a sort of a custom taken over by, from the Russians and so on and so forth. His public appearances seem to be kind of an embarrassment for the wider audience, but the president of this country himself at a certain point said, in the biggest, most reputed daily that we have, he gave an interview after people were criticizing this behavior. He said, look, Lazarevich is criticized by the same people who were killing our kids in 1999. So president is sending a very powerful message. Lazarevich is okay, and people who are bombing us senselessly in 1999 are not okay. This is basically a semi-official position. You can't put this on the burden of the ICTY. ICTY can't change Serbia or anything else. But ICTY could have changed some things. The reason why Lazarevich is free is that people who are convicted by the ICTY are simply more or less shipped from the tribunal somewhere to serve their sentence. Sweden, I don't know, many other places, Italy, and then they serve their time. As a rule, after 2/3 of that time, they are simply released. If they behave, I don't know, okay, they are deemed rehabilitated and they are set free. So almost all the people simply spend only 2/3 of their sentencing. And many people really don't know that, but this is how it happens. Now, how do they prove that they behaved correctly in prison? The usual stuff. It's what you would expect from a petty criminal. You know, you didn't do much drugs in prison, you put your bed and sheet straight, you didn't cause much problems to the authorities. Simply, it never dawned to the ICTY that there should be any meaningful rehabilitation. And that is stunning. We rehabilitate even people who do petty crimes, right? We have the assumption that they need to be prepared to come back into the society in which they wronged. So this is okay if you kind of stole something, then we rehabilitate you. But if you committed crimes against humanity, then, you know, no rehabilitation is merited. I give it to you. It's a complex rehabilitation. You don't know where to begin. But when there is a will, there is way. And this time there was no will, so the guy can march wherever he wants. He's a free man. He can lecture at whichever academy. Therefore, responsibility for this post festum of the trial is sort of joint. Those who remain in jail, they took different things. They rehabilitate themselves. General Pavkovic, who was the commander-in-chief after the war, took to painting. As you see, he is an ardent painter. And he also took to writing. He wrote four-volume strong history of his involvement in war of 1999, very heroic ode of his bravery, intelligence, military cunning. He's something between Napoleon and, I don't know, Mannheim or whatever, Rommel. This is not relevant. The relevant thing is that his publisher is Ministry of Defense, or Ministry of Defense is Publishing House of Serbia. Yet another tacit endorsement, I would say, of war criminals. I don't want you to think that this madness is somehow constricted to Serbia. Meet this bloke in a bar. You would say a random bloke in a random bar in the Balkans with a cigarette and a mineral water. No, he's not a random dude in a random bar. He is General Ante Gotovina, a person who took Croatia to brink of tears, joys, of ecstasy, of unseen proportion. He was arrested in 2005 and convicted in The Hague in 2011. As you see here, he was sentenced to 24 years of imprisonment, and then he was acquitted a year and a half afterwards by the appeals chamber in November 2012. Now, why does it matter that General Gotovina was convicted or not? Well, General Gotovina in Croatia was a symbol of a whole wartime narrative, which in the view of Croatian political system is just and is proper, and this guy was unjustly tortured by the ICTY and so on and so forth. Good people of Zagreb, which is Croatian capital, and many other Croatian cities were flocking to the city squares at the time of both first and the second judgment to see what's going to happen. There were huge billboards and video screenings just like this one, and you could see how it looked. This is the first instance verdict. He's pronounced guilty. People are, you know, desperate. And then a year afterwards, not guilty. People are in ecstasy. In Belgrade, the same information was received in completely different way. Again, just think about victims who are sitting somewhere in Belgrade, and then they are moderately happy that this guy got some sort of jail time, and then a year afterwards, you see that somebody who was found guilty and got 24 years was found innocent. It's sort of difficult to explain this to anybody, especially to an ordinary person who is supposed to be consumer, let's say, of transitional justice. if you would think that what I told you is sort of like the bottom of the barrel, you can always go lower. There are much more problems in the ICTY. People are actually dying there under different circumstances. Most infamously, Milosevic died of health concerns, of health reasons in 2006, and his whole trial crumbled with his death. More importantly, some other people committed suicide in the Hague Tribunal, and I would particularly like to mention a case of Milan Babic. He was a Croatian Serb politician during the war. He's probably one of the very rare persons among these 161 indicted who actually reflected on his wartime role. And he showed what I think is a genuine remorse. He testified in the Milosevic case, and he was subjected to quite a lot of humiliation in the ICTY by his inmates. For instance, by Vojislav Šešelj, who really loved poking and torturing him and threatening that he will do this to him or that to him. On one day, this Babic was found dead, and he killed himself. I wouldn't speculate what brought him to this, but surely the behavior of other inmates didn't really help. And then in 2017, a Croatian general called Slobodan Praljak just killed himself by drinking an amount of poison in the courtroom of the ICTY upon him being pronounced guilty. He just took the floor. He said Slobodan Praljak is not a war criminal and something along these lines, drank a poison and died shortly afterwards. So, to bring the story back to the goals of the ICTY, if the goal was ending the impunity of leaders, certainly the idea was not to end impunity like this or to hold them accountable like this. And again, you can imagine that I imagine that some of the victims are indeed empowered by the experience of coming to The Hague and testifying and telling their story, but I can also imagine that many victims are simply re-traumatized with the events unfolding in The Hague, some of which are tragical, some of which are comical, some of which are both tragical and comical, but certainly not doing justice to what had happened, or at least doing some partial justice, which is, I'm insisting on this partial justice or mixed record. Now, let me briefly turn my attention to these other two goals, developing international law and strengthening the rule of law. Firstly, I need to do some deciphering here to see what do the ICTY people think when they say so. Developing international law, by that the ICTY says the following. Okay, we held many trials and we amassed a lot of experience. There are lots of judgments and there is a bunch of applicable law which can be used to further international humanitarian law in different circumstances by different courts. That's developing international law. And the other component, strengthening the rule of law, also needs deciphering. The idea is the following. Local judiciaries in post-conflict areas are not able to grasp these enormous crimes. So the ICTY is doing different things to help local police, local prosecution, local courts to step up and basically to take over once the mandate of the ICTY comes to an end. And this is a really important, probably the most important element, because this is exactly the core of the idea of complementarity that ICC is based on. Can we make those two instances work together and not in cross purposes? Again, in the interest of time, I will bundle these two accomplishments together, and I will try to bring you to some particular situation which will probably be a good case study to what is actually happening in the field. How many of you are familiar with this photo? Wow, that's a respectable number of people. And indeed, because many people would claim that this photo is iconic in many respects. For those of you who don't know, I will slowly do a sort of a recap. This photo was taken in a Bosnian town called Bijeljina. I heard that tomorrow one of the groups is dealing with Bosnia, so good luck. This photo was taken on Bijeljina on 1st of April 1999. That is the least jokeable 1st of April that I ever heard of. This is Bosnia. Actually, this is the ethnic map of Bosnia, so-called infamous leopard skin. And this is Bijeljina region, adjunct to Serbia. What happened on 1st of April 1992 in Bijeljina? Well, a paramilitary group which was stationed in Croatia, led by an internationally known criminal called Željko Ražnjatović-Arkan, and was already infamous for its activity in Croatia in 1991, passed the border from Croatia to Serbia, and then again from Serbia into Bosnia, and they entered the city of Bijeljina, in a sense bringing the war to Bosnia, at least to this part of Bosnia. Why did they come to Bijeljina and not some other place? This is really not coincidental. Red is the Serbs, green is Bosniaks. As you see, the region of Bijeljina is pretty heavily inhabited by the Serbs, but city itself has a sizable Bosniak majority. The idea was to take over the city. And this is what they did, killing a dozen of people or a couple of dozens of people in the process, launched the process which will eventually lead to the situation as it is now, that Serbia is almost entirely Serbian Bijeljina is almost entirely Serbian city. This paramilitary unit was called the Tigers. This is the head of that unit, above mentioned Željko Režnjatović Arkan and his Tiger. The other members of the unit are wearing balaclavas because they are not such media freaks as Arkan and they don't like their faces to be seen, which is logical given what they did in Bijeljina and other places. Okay. So in the course of their activity in Bijeljina, they were passing through different houses, doing different things. At a certain point, they passed through a house of a local butcher called Šabanović, and what they did in the house was the following. They understood that many people are hiding in the cellar. They started killing people in the cellar, but they also killed some people in front of the house. And this is Tifa Šabanović, butcher's wife. And after they were killing them, one of the soldiers kicked her in the head, and this is the moment when American photographer Ron Haviv, who was hiding behind the vehicle somewhere where I am now, let's say, took a series of photos, this one being the most important. Now, why am I giving you all these details? Well, if we look at all those crimes forensically, you would think that if there is ever a forensically solvable crime, this is a forensically solvable crime, right? We have a victim, we have an aerial of the house, we know exactly who came to Bijeljina, we know who are people in this picture, so in a sense you would say the case is closed. This is the guy who was kicking the woman in the head. This is the head of the unit, Željko Režnjatović Arkan. This is Arkan behind Milošević at the given funeral. And you would think that even some sort of chain of command can be reconstructed on the basis of this. But you can't. Because of course Milošević was not the person giving direct orders to Arkan, telling him go here, go there, go to Bijeljina. For this purpose, most probably, Milošević was using the heads of security apparatus, bosses of Serbian Secret Service, Jovica Stanišić and Simatović, Franki Simatović. The thing is the following. Simatović and Stanišić were also indicted by The Hague in 2003, and they were on trial for about 10 years in the Hague Tribunal. And in 2013, and I was living in Amsterdam at that point, because firstly I was interning in the ICTY, I was then historian in Belgrade, then I was working in the Serbian prosecution office for 2 years, then I resigned, and then I moved to the Netherlands for postdoctoral studies. The stay in Netherlands was great for 2 years or so, but I literally remember that one of my worst days was the day of their acquittal in 2013, because I was really thinking that putting them on trial would be an important thing for Serbia. They were acquitted. Now, this was a lousy day because I really understood what's going to happen in Serbia. The moment those two people walked free from the ICTY, all hopes that any investigation in Serbia will tackle people like this gentleman and these people came to nothing. Because simply if the ICTY is acquitting these guys and they are coming to Belgrade, they are really influential secret servicemen with their connections and the fear they bring and even vengeance, you really need to find a very brave police officer or a prosecutor to try to search for their underlings. So we saw a story here of a forensically completely solvable crime which was cut from below in Belgrade and cut from above in the ICTY. This story didn't really come to an end because these people were acquitted in 2013, but then the retrial was ordered. So Stanišić and Simatović are still on trial now in The Hague. And there is still a certain hope that perhaps they might be convicted of something or some connection can be established between them and Arkan and this guy, and then something can roll in Belgrade. And actually, I just came back to Amsterdam. I was at the conference in Amsterdam where I was waving, just like I'm waving with a piece of paper to you now, I was waving that same piece of politica to the chief prosecutor of the Hague Tribunal in the case of Stanišić and Simatović. I told him that it's highly unlikely that we are going to do anything about this in Belgrade unless this is somehow used by them in the ICTY. He said he's perfectly aware of that. They are on the case. I need not bother, and so on. Let's see what happens. Stay tuned. If in the course of a following year or 2 years you hear a random bizarre news that some DJ, just remember DJ, was arrested in Belgrade, you will know that this story actually came to some ending. If you don't hear anything, then we failed, and it's very likely that this is actually yet another judicial failure. How does it relate? So it's clear that strengthening of rule of law didn't really occur, and the national jurisdictions were even discouraged from time to time to do anything about it. But developing international law is also a dubious claim. Because why were Stanišić and Simatović acquitted? I was talking to a judge who acquitted them, and he said, I had no choice. The standard changed. And I was, of course, as every naive, non-legal guy, I was like, okay, so which standard? What are you actually talking about? And he said, well, there was a standard at a certain point that we needed to prove only that these guys, Secret Service bosses were giving assistance, financial, backing, logistics, whatever, to these guys, and that would be enough to say that they were controlling them and hence they are responsible for their doing. But then the standard changed in 2011 in another trial, and now the court had to determine that they gave them help knowingly and in the know that these guys will commit these crimes. So you have to prove not only that they were giving them weapons, but also that somehow they gave Arkan weapons, and Arkan told them, you know, I'm going to kill those people in Bijeljina, right? And then these people said, of course, this is why we're giving you the weapons. So basically, they changed the standards as they were going, and this is not the only standard. In Gotovina case also, there was an issue of standard of how many meters there can be if you're shelling a certain military location and some civilians die. Is 300 meters reasonable or unreasonable distance for it to be claimed malicious act and not collateral damage? So just imagine, how can you use this applicable body of law? Even if ICC was in full function, even if all these case situations are in the making, I don't know how would they make some sense out of all that mess. I want to dedicate a bit of attention to the fifth accomplishment of the Hague Tribunal, because I think it's most important for us non-legals or us people interested in transitional justice, establishing the facts. ICTY claims that the activity of all these trials, at least collaterally, brought to existence a number of information pertaining to the war in the former Yugoslavia. And indeed, heads down. I'm a historian. I know very well that if it wasn't for this judicial intervention, we would never see documents which I'm dealing with daily. Documents of highest confidentiality from 1990s or even from early 2000s. It simply doesn't happen in the former Yugoslavia. So we saw a lot. Judicial database, which is publicly accessible and you can all log in. If anybody's interested, I would be more than happy to clue you in how to do that. And this is this judicial database, contains so many information, around 100,000 only evidence which were exhibited in all those trials. Just imagine, 100,000 evidence. That's really, really a lot. Plus many other documents related to trials themselves. But here now we are talking of documents of historical importance. So it's a great thing. And of course the ICTY does a lot to promote this indeed sizable achievement. This is a photo taken from Sarajevo. In Sarajevo a couple of years ago, I don't know exactly when actually, so-called info center was opened of the ICTY. Because ICTY for a long while was under criticism that they didn't do enough of outreach. That they did amazing trials, but they were not interested in the region they were covering. So basically all these amazing things remained hidden in The Hague. And so if they would have an excellent outreach, then people in the Balkans would say, oh wow, okay, if you did all these lovely things, then we are fine. This was the idea. And now in the beginning, The Hague didn't have any outreach. Now The Hague has excellent outreach. But the irony is in the following. The ICTY's stellar years were up until 2005 or 6. This is when they didn't have outreach. And then enormous decline started. They had the outreach, but they didn't have the product anymore. This is my evaluation of this interesting phenomenon. So within this sophisticated outreach, in Sarajevo, in quite a vulnerable place called Vijećnica, that was the library before the war, but the library was burned by the Serbian forces, and now it's sort of a public space. They made a replica of the Hague courtroom. I went to see it. It was closed. 2 p.m., but hey, okay, all right, didn't work. Nonetheless, even I wasn't feeling sorry because even if it worked, I know what I would see. I would see a replica of a courtroom. The purpose of this place is to deliver information about the ICTY. So somewhere hidden in this courtroom, there is a computer which will give you exactly this. The same judicial database that you can access from wherever you want, from here or from your house and so on and so forth. So you couldn't really say that this is a move forward. Of course, it was open with a lot of pomp and circumstance, but what people tend not to know is that below this judicial database, there is an enormous prosecutorial database. Judicial one contains 100,000 documents, prosecutorial one contains over 2 million. Probably they amassed from my time even to 4 million and so on. The prosecution is absolutely disinclined to open up that prosecutorial database. Many of my colleagues were negotiating with them. We were offering money, know-how, students or anything, but they were absolutely disinclined. No, not students to put in jail, students to help organizing those documents. Because the problem is in organization. Documents in the judicial database are organized according to the cases. They don't follow the logic of scholarly research. What we need to we need to kind of recomb all that and to retie documents with some other logical elements. So they said, no, I can only speculate why. It could be laziness. It could be actually, they might be worried what's inside because they themselves don't know. 4 million documents, you need a legion of people to go through that. This is not an unknown phenomenon, to put things a bit in comparative perspective. Even if the Hague Tribunal opened its vaults and its all archives, they would fall on shoulders of really weak academic community. This is how Nuremberg looked like in 1945. This was sorting of documents for the Nuremberg trials. Just look at this mess. And the mess came from simply, again, just think of the scope of transitional justice once you put it on paper, once the papers pass the court. Nuremberg material amounts to about 2,500 pages, and we are talking judgments only. The court transcripts total 134,000 pages, etc., 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 42,000 exhibits, probably each exhibit would be 50 pages long, and so on and so forth. You do the maths, in a lifetime, nobody can read all that. The Nuremberg Tribunal understood this phenomenon. There was really an interesting guy called General Talford Taylor. He was a member of the American team in the first big Nuremberg, IMT, and then he was organizing NMTs, 11 huge trials organized only by Americans in Nuremberg to different aspects of the German political, military, economic, medical, judicial elite. Very interesting trials. Actually, in many respects, much more interesting trials than the IMT from the point of view, if you're interested in the fiber of society, those trials are much more important. So this guy, Talford Taylor, finished all this, wrapped it up in 1949 or something like that. Over 180 people were prosecuted in that process. And he said, well, we have to publish all this. Because in a sense, he said, Nuremberg is not only what had happened there. Nuremberg is sometimes what people think happened there. And this second part might be more important than the first part. So he did his best to secure some funding to organize collected works of different kind, judgments, transcripts to be published, and so on and so forth. But that venture goes up to 100 volumes, and it didn't even scratch the surface of the Nuremberg documentary legacy. Why am I mentioning the Nuremberg documentary legacy? Because if you compare only one trial in the ICTY, and this is trial to Slobodan Milošević, you would see that the legacy is, well, that the situation inflated from Nuremberg days. Only his trial, out of 161 trials in the ICTY, is almost half a Nuremberg size. We are talking about transcripts of almost 50,000 pages, and this is unfinished trial. Almost 100,000 pages of documentation, exhibits, and so on and so forth. I took a photo yesterday in my own house. I can't house the transcripts. See, I have to put them in two shelves, actually 2 lines in one shelf, because Humanitarian Law Center in Belgrade, an NGO which in many ways was supplementing for the lack of any sort of meaningful investigation into war crimes in Serbia throughout the 90s and 2000s, decided at a certain point to publish those transcripts in Serbian language to make it accessible to people. And this was an enormous project. It ended up with 50 volumes of Milošević transcripts. Again, a question is how to approach this. 50 books right in front of you, right? We have the can, but we don't have the key. Furthermore, even if all those information would be publicly available, how do you make public consume them in a meaningful way? There was a series of public opinion surveys in Serbia, and not only in Serbia, but throughout the region, about how people relate to war crimes. And many answers were quite interesting. I will not bore you now with details, but I will give you only one answer that people tended to give. So people were asked, to what extent do you think you're familiar with the organization and work of the ICTY? And as you can see from responses, majority, dwindling but still majority of people said that they are not informed enough. Either informed a little about the ICTY or not at all. Now you ask those same people, do you think that ICTY judges are generally biased? And the overwhelming majority tells you yes. Now you tell me, I mean, for the life of me, I can't understand how a same person who says that he or she is not acquainted with the ICTY can tell you and knows that those people are biased. He just told you that he doesn't know, and yet he tells you that judges are biased. I don't want you to leave with an impression that ICTY didn't do interesting and important things in the field of transitional justice. There have been enormous successes. Probably the most interesting one was in 2005 and 2006. A footage was screened during Milošević trial, and this footage was showing executions done by a Serbian paramilitary unit called the Scorpios. And after the screening of that video in The Hague, these people were arrested in Belgrade and in the neighboring cities, and they were put to trial in Belgrade by the local judiciary. So this was this kind of complementarity at work. But in that same year, while the trial was unfolding, this public opinion survey asked good people of Serbia, are they aware of any crime processed by the local prosecution? And people were largely unaware. 60% of people was unable to say anything about any prosecutions. Only 6 people knew that something in regard to Srebrenica, which is this Scorpion case, is being prosecuted in Belgrade. So there is not a question only of enormous quantity of documents, but how to make people read them or actually have any meaningful takeaways from those documents. I didn't know whom to blame for the situation. I started blaming the database, the ICTY database. I was even yelling at the database sometimes later. Oh, you database, if you were only simpler and, I don't know, in Serbian and if documents were arranged. But after a while, I grew mature. I understood probably it's not the database. Is it the documents? I thought that probably people might react better if we would supplement the effort of Humanitarian Law Center, which published transcripts, and if we would publish a couple of volumes of key documents from the Milosevic trial. And my institute in Belgrade published those documents, some with the Humanitarian Law Center. And we came to the 10th volume, and then we sort of discontinued the project because we understood that people are not really eagerly reading those documents, so that the avenue taken by General Taylor in Nuremberg might be a bit outdated by now. So I'm set to conclude that even in this fifth element of establishing the facts, The Hague also leaves a sort of a mixed record. Are those the images? And this slide is purposefully blank. At a given point, I came to the conclusion that probably this generation is way too visualized and that you can't reach out to people by books or by lectures or by keynote addresses and so on and so forth. And I thought that the images might give sort of a breakthrough, just like in the Scorpio case. It seemed logical. But I have to say that I'm disappointed on that front as well, because I did a couple of focus studies with a number of students who were born well after 1990, and they have second-hand experience of war. I was showing them different photos, such as the one I showed to you, but number of hands was like 20% or even less. People couldn't recognize even this Stanisic Simatovic guy, so Secret Service bosses. They would remember Milosevic and Mladic, and this was pretty much it. So basically, my concern is that we are leaving this poisonous legacy to the next generation big time, and I am slightly skeptical about the role of images. They will not speak for themselves. You think that the image will speak for itself, but I wonder. I guess it's as toothless as the document if proper context is not retrieved. I think it's slowly time for me to wrap up, and I was wondering how to put this thing, how to wrap it up in a meaningful way, because it's an unhappy story, and I don't want to leave it at that, because I don't think it's an unhappy venture. What I think is happening here is the following: that time and again we have inflated expectations. We expect a lot from the courts, international courts as well as national courts, and then time and again we are disappointed. Actually, I don't even know why we are so disappointed, because the courts in many ways are set to fail. The point is the following, and this is why I tortured you so much about the ICTY. If ICTY couldn't do it, if ICTY couldn't satisfy our expectations from the court, and mind you, ICTY had a quarter of a century. It had more money than you could possibly imagine. It was dealing only with one crime scene, which they could intimately get to know, and it was dealing with overlapping cases. And still, we are not satisfied at all with the product, and at best, again, we can say it's a mixed record. Then for sure, no court conceivable in our days can't do anything like that. The least ICC. This is the first takeaway. And in such a situation, actually, we have to think, firstly, why is that? I think there are many reasons. The first and the most important reason comes from the very nature of those crimes. Those are collective crimes. Those are mass political crimes. Only in the case of Yugoslavia, there were over 130,000 fatalities, certainly majority of those fatalities in criminal circumstances. Imagine how many perpetrators. I even hesitate to name a number. Who will prosecute those people? Nobody, actually. Such crimes, as a rule, blow limits of law. Nobody wants to admit it openly, but they blow limits of law, which means that whomever you put on trial can claim to be a scapegoat. An ordinary goon on the street can claim that it's not him, it's Milosevic. Milosevic can claim, look, I didn't go and kill all those people myself. The middle-ranking person would say, I was just a pencil pusher. So basically, if you simply can't come to the terms with the fact that you can't prosecute everybody, then you have to come to the terms with the fact that this justice will always be selective and partial. And then we need to take this as our starting point, and then we need to see how to carry that through. Now, how to carry that through? Well, courts cannot do much. They can do very little. But this is precious little, and this also needs to be acknowledged. I didn't come here to badmouth ICTY or any other court. I deplore the fact, I'm saddened by the fact that they can't do any better. But in a sense, we have to understand that this micro product they give, a judgment here, a judgment there, a guilt established beyond reasonable doubt for this or that, acknowledging that persons by names and surnames died there, that matters, and that precious little should be salvaged from this general political brouhaha of whether the court acquitted Bemba or not, and so on and so forth. So, what is actually the message for people who are in general studying transitional justice, such as yourselves? In my view, it's really important to recognize the limitations. And when I say recognize the limitations, I think to recognize limitations of the courts, but also our own limitations. We all want to do good, I will not challenge that. But we have to think about our own disciplinary limitations, whether we are competent to be at the same time historians, jurists, sociologists, psychologists, and so on and so forth. Much of transitional justice work I encountered is way too emotional and way too political in my view. It's about giving a statement. I am against war. I sympathize with the victims. And that's fine. And I do as well. But when we come down to business, we need to think about it in a strategic way. What do we want to achieve? How do we set our goals? How do we develop strategies to do this or to do that? And how do my limited abilities of a historian or a pencil pusher or whatever fit into this strategy of trying to achieve anything? I think that would be perhaps a bit more pedestrian, but probably a sounder approach to transitional justice at this point. Also, I have another sort of a piece of haphazard advice. I think that disillusionment, which probably speaks from me throughout this evening, shouldn't be confused with disappointment. I was very much disillusioned by many tribunals simply because I had illusions about them. But that doesn't mean that one is completely disappointed with the outcomes. One shouldn't confuse the two. And one should simply move forward, understanding that the courts are only part of this sophisticated story. One should think two ways. How do those findings actually can be meaningfully integrated with results of different commissions, different public hearings, parliamentary committees, public activism, all those things that we are all taught and that you are taught here and elsewhere, which are called tools of transitional justice. This is what we have to do. The other one, and extremely important, is comparative aspect of this whole story. Why do people get disillusioned and disappointed and bitter and simply go around like me with some old newspaper and saying, look, this guy killed that guy and nobody is doing anything about it? Why? Well, because they are completely suffocated in their own story, in their own region, in the crimes committed which bother them because they know the killer, right? However, comparative aspect, and this is why I applaud this school, and I'm so happy that it's the 10th year that we are here, is taking us out of our region, forcing us to understand that other people are suffering as well, that there are enormous crimes happening in the Middle East as we speak. We take a look at what's happening in Venezuela, we take a look at what's happening, we go to Ukraine, and then we understand a bit better ourselves and the conflicts which basically destroyed the society of ours. So this is the enormous importance of comparative aspect of this research. The last thing I want to mention is this working with the next generation. And I don't mean it in a cheesy way with the next young generation which is coming unburdened with this past and so on and so forth. Working with the next generation is extremely refreshing, and this is why I would always come to give a keynote on a summer school, because it gives us fresh insights about the tools we can use. At this point we are developing, my colleagues and me are developing a sort of an interactive database. A database which will use informational technologies in order to resort the Hague documents, and we are going to test them with the students. We are getting ideas from the students. I understood at a given point that propaganda which is spread by, let's say, Vojislav Šešelj doesn't go the way I think it goes. He publishes a book or holds a speech and so on. No, it's through YouTube channel. Simply, his YouTube channel had 1 million hits at a certain point. The kids are laughing, they're sharing his profanities and whatnot, and this is the channel. So what you need to do is simply to work with this next generation and understand what are the tools they are using and to adapt to that. Of course, it goes without saying that we are doing this for the next generation. Only yesterday evening, my daughter, whom you all had pleasure to meet, asked me, oh, Daddy, what are you going to speak about? And it's challenging to say that, right? So I told her, well, I will try to speak something about bad things some people do, and I will consider what we can do about it. And then she gave me the cartoon line. She said, well, we can fight them. I guess it comes from Patrol Pose or something. And it was really impressive and endearing to hear, the more so as it reverberates with a quote I wanted anyhow to use to end this lecture. And the quote comes from Benjamin Ferencz, whom you, I hope, didn't remember, young prosecutor from the NMT going prominent into the ICC. So let's see what he has to say about these topics.
I am often asked whether I am optimistic or pessimistic about the state of the world and what we can do about it. The answer is that I am realistic. I see the problems very well about the International Criminal Court, for example. But I also see the progress. The progress has been fantastic. There has been a slow awakening of the human conscience. When I went to school, there was no such thing as human rights law, humanitarian law. There was no such thing as women holding key positions. When I see all of that, I know that we are moving in the right direction. What's very important is 3 pieces of advice I always give to students. 1, never give up. 2, never give up. 3, never give up.
The man is 100 years old almost, so better believe it. I have no better ways to conclude this keynote, so I thank you for your patience.